welcome to join us for this webinar. It's the follow-up webinar on the patent for chemists protecting your invention. So today we have two presenters from Abel and Imray. So they are going to give us a talk about how to make your patent and also to protect your IP during your research. So now our first speaker will be Dr. Tom Turner. Tom is a European and chartered UK patent attorney and also a partner at Abel and Imray. So Tom had a PhD from University of Bristol, and Tom's work on patent relates mostly to industrial chemistry with a special focus on polymers, reactor technologies, and he is involving in drafting and operating work in the UK and Europe. So let's welcome Tom. Yeah. Tom, are you ready?
Yes, thank you very much for the introduction, and thank you for having us back to speak again. You mentioned we are sort of following up on a webinar we gave in November last year and continuing on this theme of sort of a bit of an introduction on patents for chemists. So on today's talk, we have a few things to cover. We'll start off with a brief introduction to ourselves, and we'll do a bit of a recap as an introduction to patents. Some of that material is similar to our previous talk, so I won't spend too long on that. But just in case some of you haven't seen that, I thought that might be useful. This time we're going to move on to some slightly different topics. We're going to look at inventorship, so that's who is an inventor on a patent and also who owns the patent. Some thoughts on strategies for protecting ideas, the kinds of intellectual property you might be wanting to think about, and then rounding that sort of introductory bit off with the value of intellectual property. So why file in the first place? And we're going to illustrate that point on value of IP and what you might want to do with particularly patent rights with some case studies towards the end. And those case studies are based on the approaches that real life companies have taken to getting value out of their intellectual property. We'll have a summary then, and there'll be time for a few questions at the end. So if you do have questions, I think if we can collect them as we go along, and then we can cover them afterwards. So, quick introduction to us. We are here on behalf of Abel and Imray. We're a firm of patent and trademark attorneys based in the UK. We have offices in London, Bath and Cardiff. I'm based in Cardiff and Katie in Bath. You'll see from the banner across the top that we're 150 years old this year. We first formed in 1871, so we're almost the oldest patent and trademark firm in the country. I think we're the second oldest and still going strong. Our work, we represent clients before the UK Patent Office, so the Intellectual Property Office, that actually handles designs and trademarks as well as patents, and at the European Patent Office, that's just patents, and then finally at the European Union Intellectual Property Office. There are lots of different acronyms there, but that last one handles trademarks and designs at the EU. For work outside of the UK and Europe, we work with a network of overseas attorneys. So that would be patent attorneys, etc., based in the US or Japan or wherever. And most part of our work is preparing, so drafting, filing, and prosecuting patent applications. In our world, prosecuting means the negotiation that gets a patent granted. So a patent office usually examines a patent for whether it should be granted or not, and we represent inventors in that stage. And of course, we also provide advice on existing IP rights. So that might be the infringement or validity of rights, and that will be IP rights belonging to our clients and also third parties. That's a sort of another big part of our work. So that's what we do as a firm. That's what our role is. So me, provide a bit of an introduction already to me. As I said, I'm a European and UK patent attorney. I'm pleased to say that the European patent system isn't an EU system, so I am still a European patent attorney even after Brexit. I'm usually in our Cardiff office, although mainly working from home for the last year or so. Before I became a patent attorney, I did a master's degree in Durham, and then a PhD in Bristol. I was in the Pringle group. I worked on developing catalysts with diphosphine ligands on palladium for the methoxycarbonylation of ethylene. Is what I spent my few years there doing. But since being a patent attorney, my work is a bit broader than that. I do quite a bit of work in industrial chemistry, so petrochemical refining, polymer formulation, some work in catalysis. And then away from that sort of more heavy chemical stuff, I work on a fair amount to do with food products and processing, and something completely different is data center design and operations. So these are these big warehouses full of computers. Keeping them cool and operating them efficiently is quite a big part. I'm joined today by my colleague Katie, and I'll pass over to her for her introduction.
Thanks, Tom. So I'm just going to briefly introduce myself. So I'm a trainee patent attorney. I started my career at Abel Imray about 3.5 years ago. So I'm quite far through the training process and hopefully be qualifying fairly soon. So I also have a background in chemistry. So I did my MChem at Cardiff University, and then I also made the move to the University of Bristol. And there I worked in the WAS group, and I developed catalysts for converting ethanol into advanced biofuels. So my patent work, patent portfolio is quite similar to Tom, because I assist him on quite a lot of his cases. But I also do a fair bit of work in the pharmaceutical sector and on medical devices. So that's the introduction to us. So I'll hand back to Tom to start the main part of our talk.
Thanks, Katie. We covered some of this last time, but just as a bit of a recap, what are patents? So patents are intellectual property rights that have been granted by a government. So that means that they're territorial. They apply in the territory or the country that has granted them, and they're time limited. They only last for 20 years. That's 20 years from the date that the application was first filed. And once that time has run out, that's it. There's no patent anymore. They're there to give protection for technical inventions. That means that patents are concerned with technical function, how something works, how a problem is solved, not really how it looks like, and ideally not the specifics of sort of one particular embodiment, but generally what has been solved by an invention. And when you have a patent, the owner is given the right to stop others from using that invention. That's the right that a patent gives. It's to prevent other people using it. But the deal is that exclusivity is provided in exchange for telling everybody how the invention works. So the ethos underlying the patent system is that it encourages inventors to tell everybody how their invention works, so that they get this period of exclusivity. And then when it runs out, everybody can use it for the benefit of everyone else. So that's the idea behind it. And Katie's going to carry on now.
So you might remember this slide from the talk back in November, but I've put it in again because it's really important and key to the patenting process. So in order for an invention to be patented, it has to be novel, it's got to be inventive, and you also have to sufficiently disclose it. So novelty means that the invention is different over anything that's already known. So when we assess an invention or a patent application, that's done against what we call the prior art. So the prior art is any public disclosure anywhere in the world that was made before the patent application was filed. So the invention needs to be new over all of those disclosures. So novelty is quite a low bar. You're just looking for any kind of difference. And I think this is a good point to raise, that you should be really careful of your own disclosures. So if you were to disclose an invention before filing a patent application, say in a research paper or at a conference, that will form part of the prior art, and therefore you won't be able to get a granted patent for that invention because you've disclosed it. So your later filed patent application, that invention can't be new over what you've already disclosed. So do be really careful about at least thinking whether you want to file a patent application before disclosing. The next requirement is the invention must be inventive. So that means it's not an obvious modification or a combination of the prior art. So we're looking for an inventive step here, not an inventive leap. So you don't need to be coming up with an invention in a new technical field, but you have to do more than a routine or obvious modification of what's already known. It's a bit more tricky to determine if an invention is going to meet this inventiveness requirement, but a good thing to do is look for any advantages that your invention is providing. So it could be that you've got a process that's more efficient, or perhaps you've developed a catalyst that makes something in higher yield or selectivity. If you can pinpoint a problem that you're solving, so previous catalysts don't produce something in high selectivity, that's a problem. And if you're solving that, that's going to be an indicator that your invention is inventive. And then finally, we've got this requirement for sufficiently disclosing the invention. So in the patent application, you need to provide enough information that the skilled person, so that's someone who works in the same kind of area that the invention relates to, they need to be able to work and repeat the invention. And Tom and I, in our last talk, we went through how you think about what sort of data you want to include in a patent application. And I'll just say again that it is important to include plenty of detail in a patent application to make sure that you're meeting this sufficiency requirement. So once we've thought about is our invention patentable, potentially patentable, then we also want to think about ownership of the invention. And this is important because the person who owns the invention, they have the right to be granted a patent. It's important to think about ownership very carefully early on because you want to avoid any disputes further down the line. And in a worst case scenario, a patent can actually be revoked if it's been granted to the wrong person. So ownership flows from inventors. So first of all, we need to think about who the inventors of an invention are. So the law actually doesn't offer too much guidance on who an inventor is. The law simply states the inventor is a deviser of the invention. So you can have one or multiple inventors. And an inventor is someone who made an inventive contribution to the subject matter of the invention. So they contributed to the idea. An inventor wouldn't be someone who merely gives advice or assistance. That's not enough. You really need to be making a material contribution to this inventive concept. So it's quite a strict requirement, naming inventors, and I like to compare it to naming authors on a research paper. So for a research paper, you typically have quite a few authors, and that will be anyone who played some sort of part in that research program. People who are named as authors on a paper wouldn't necessarily be named as inventors on a patent. So a person who came up with the original concept of the invention, they would be named as an inventor, and they would also probably be named as an author on a research paper. Someone who further developed or improved the original concept, they would also likely be named as an inventor and an author on a paper. But someone who followed their supervisor's instructions, they conducted experiments that they were told to do, and they didn't bring any new ideas to the table, they would most probably be named on a research paper, but they wouldn't probably be deemed to be an inventor on a patent. And I'll just quickly mention that inventors always have the right to be named on a patent, so that's regardless of whether the inventor actually is the owner or not. You do always have the right to have your name as an inventor on the patent. So then if we move on to think about ownership, So we've thought about who our inventors are. And the default position is that the inventor or inventors own the invention. However, this may change, and it's actually quite a complicated area of law, and it's very dependent on the specific circumstances. But I've created this flow diagram just to give you a kind of idea of how ownership might move to different entities. So the exception to the inventor, the main exception to the inventor owning the invention, is if they are employed at the time of devising the invention. So if they're employed and they came up with their invention as part of their normal course of duty, so as part of their job, and an invention might be reasonably have expected to arise, so the person is paid to invent, in that case, the invention will belong to the employer. So an example is a research scientist. They are paid to invent. We fully expect that an invention might arise during their job, and therefore anything that they come up with during their employment will belong to the employer if it's related to their job. In contrast, someone who, say, worked in administration, they aren't paid to invent, so they would remain the owner of an invention. If a person isn't paid to invent, we also need to give some thought to whether they have a special obligation to the employer. So this really applies to senior levels in a company, senior managers. They, in certain circumstances, have an obligation to the employer, and therefore the employer will own the invention. In all other cases, as I said, usually the inventors remain the owners of the invention, but you can have agreements to the contrary, and that can move ownership on to third parties. So I think my takeaway message from this is really think carefully about who your inventors are, because ownership flows from them, and you don't want any surprises later on by forgetting or adding too many inventors. And also, this is a complicated area, so I advise seeking legal advice if this question of ownership comes up. So now I'm going to hand back to Tom, who's going to go on to our next topic.
Great, thanks, Katie. This is a slight change of tack now, leading more towards some of the case studies we're doing, and they will touch back on some of those points of inventorship and ownership as well. But let's think a little bit more now about the sort of wider picture of protecting ideas. And this is really just a sort of summary slide to introduce this change. We are talking mostly about patents in this today. That's mostly what we're concerned about. But for businesses, innovative businesses, there's more to just innovation than patents, and so it's worth knowing what other forms of intellectual property protection are out there. Top of the list we've got there, patents, that's what we do. So that's technical inventions, solving problems with some sort of technical means. I've put software in brackets afterwards. If you have looked at sort of patent protection or read things around, you might see quite often that people say that in the UK and Europe, software itself is not protectable by a patent. And that is true, but the nuance to it, though, is that if the software does something technical, so if it gives some kind of improvement outside of the software itself, if there's some problem that it's solving, then that problem being solved may well be an invention that is protectable. So it is worth keeping in mind what software is doing if you're working in that sort of area. Away from the technical stuff, the appearance of products and items, that comes in the field of designs, and countries offer design protection. Again, this is term limited. It's a bit like patents, only it's 25 years in the UK and Europe rather than 20. That can also be used for graphical user interfaces as well. So it's not just physical products. When it comes to brand identity, that is a matter for trademarks. This will be logos or taglines. Those are not time limited, so as long as they carry on being used, they will persist, well, forever, effectively. A few of the early trademarks have been going strong for 100 or more years now. For things that remain secret, so stuff that will always stay confidential, we do have trade secrets. Trade secrets are not registered rights, but there is protection there for know-how, and theft of trade secrets or copying trade secrets is something that can be, well, a problem and can be protected against, but I'm not going to cover that now. That's kind of the opposite of the patent system, really, which is intended to get information out there in the public domain in exchange for protection, but secrets have to stay secret forever. And then finally, we have copyright. Copyright is protection for sort of images and text, and it is, the clue's in the name, really. It provides protection against copying. So it's if someone actually copies it, then you might have some protection there. When it comes to a strategy for protecting ideas, there are things to think about, such as where you might want to get protection and when you might seek protection. I said earlier that patents in particular, and it's true of patent designs, trademarks, these are all national rights or awarded by territories, so they are all geographically limited in some form, and this means that it is worth thinking about what kind of where you really need to have protection, because if you start filing patent applications in every country around the world, it gets very expensive very quickly. I'm going to touch on some of that again with our case studies, but that's the point there. It's you might not want to protect everywhere. And when you file for protection also matters, because patents and designs are term limited. Filing too early could be a bit of a problem. So you need to think about when you need that protection. And we covered some of the when file a patent questions in the last talk. So perhaps you could have a look at that, or if you have any questions. The key point there is you obviously need to file before things become publicly known, but maybe not too early. And then it's back to Katie.
Thanks, Tom. So I think now for this part of the talk, we're going to have quite a bit of focus on the value of intellectual property and how intellectual property can be useful for businesses. And I think the first thing that people probably think about when they think of the value of intellectual property for a business is that it protects the technology and protects brands. So that means that these intellectual property rights can be enforced against competitors that are working in the same or very similar spaces, but also just having a strong patent or intellectual property portfolio that can be enough to deter copyists in the first place. So hopefully you won't have to go as far as actually enforcing your rights against a competitor. I think there's some additional value that intellectual property has to a business, and one of those is that having patents and protecting your technology, it really highlights your status as an innovator. So that can be a really useful marketing tool. So if you think in adverts, how often do you see patented technology mentioned, because it's selling you the idea that this is cutting edge and technology that you really want to buy. Linked into that, intellectual property can be really useful in attracting funding. And I think that's something that's very important for startup companies and smaller businesses. So by showing that you're an innovator, that's going to attract investors, because hopefully they're going to think that your business is going to come up with more ideas. You've already got a proven track record. So you hopefully have more technology that's going to come out of your business. And also having this intellectual property protects investment, because you can prevent competitors working in the same area. Intellectual property is also very useful in joint ventures. So this could be universities collaborating with industry, or if two companies come together to further develop something. It's really useful to set out from the start who owns what intellectual property and define exactly what is owned. And that will help avoid disagreements further down the line in those joint ventures. And finally, intellectual property is just that, it's property. So like any kind of property owned by a business, it's a valuable asset. You can sell or even mortgage intellectual property, And also technology that's covered by a patent can be licensed to third parties. So that can be used to bring in additional revenue streams to a business. So next, Tom and I are going to go through 3 case studies, which we've come up with to try and illustrate how IP can form an integral part of a business and how you can think about your IP strategy when you are coming up with your business plan and what you want from that business. So in the first case study, Tom will discuss a company that developed their own technology and then licensed to third parties. Then I'll talk about a startup company that developed their technology and then went on to sell the company. And then finally, Tom will round things off with talking about another startup company that kept their technology in-house and developed it and marketed it themselves.
Great, thanks, Katie. And one of the things that you'll see through this is that these sort of 3 different approaches that we split out there, they can influence the kind of intellectual property that's sought, particularly when it comes to where you get IP protection and sort of how broadly, depending on what you want to do with that. But let's move on to the first case study. So you'll see from the title there that we're not talking about a startup now. We have Unilever in the top there. This is actually drawn from a quite a contentious piece of litigation, but I'm not really sort of focusing on what was the subject of that. That was all to do with inventor remuneration, inventor award for coming up with something. But I think the background to it does give quite a nice example of this coming up with technology and then licensing out idea. So the background to all of this is that Professor Shanks was an employee of one of Unilever's various companies, and he was part of their research arm. So they had an entity in the UK that employed all their research scientists, and he was one of them. He worked in biosensor development. While he was there, one of his interests turned into an invention of what became called the electrochemical capillary fill device, a slightly complicated name, but anyway, it was this device was made up, or his invention was conceived as a couple of thin plates with a little cavity between them, and that made a capillary tube. And then in between those plates, inside the cavity, you could put an electrochemical sensor, and that could be an immobilized enzyme with a printed electrode inside. The idea here is that a fluid to be tested is drawn into the tube by capillary action and brought into contact with the sensor, and then the sensor can make some kind of reading. Ultimately, this has gone on to be used in glucose measuring devices. And that's what's shown in the little picture in the right-hand side there. So you put a little droplet of blood on the end and you get an immediate glucose reading. These devices now are very widely sold. You find them in pharmacies all over the world, and they've been really, really useful. But Professor Shanks came up with this this concept sort of while working. He actually made his prototype at home. He used slides from his sort of daughter's toy microscope set to make this, and sort of presented that to his employers. What is worth mentioning, just to circle back to what we spoke about earlier, is that ownership of this was never disputed. Professor Shanks was working as a researcher and employed to invent, and although the prototype might have been made at home, this did relate to his work, and so it was the case that Unilever owned the rights, and so that never really came into question. But how did IP fall into sort of the commercialization strategy here? Well, Unilever's research arm sort of looked at all sorts of different things and actually concluded that this particular invention, which had this sort of application in glucose blood level monitoring, wasn't something that they were going to commercialize. There are plenty of other companies in this kind of field, and I think it was a business decision not to try and break into that. But the technology was still protected, and it was protected with patent applications that were filed a while ago now in the 1980s, ultimately granted in quite a few countries around the world. You see some pretty key economies there, across Europe, Australia, Canada, Japan, the USA. And I say Unilever didn't really carry on much much further work in this field, but other people did. And other companies were actively developing these kind of sensors, and by the sort of mid to late 90s, were wanting to bring products out. Because Unilever had these patent rights, which were quite important in the field, they were able to license that technology out. So they had no interest in commercializing it themselves, but they did license it out, and the license fees came to the best part of £20 million, which is pretty significant. Ultimately, the patents were then sold as part of an entity that Unilever sold off, and that made some more money, about 4 million. What's interesting, I guess, is that the patenting process is not particularly cheap. Getting patents filed and then maintaining them once they're granted did come to a fair amount, £250,000, but compared to the licensing revenue, that's not that big. Had Unilever not patent protected this, had they not recognized that this technology had some value to others, even if not to them, there wouldn't have been any revenue from this at all. And so what I'm using this case study to illustrate is that even if a piece of technology is not really suitable for commercialization by the inventor or the inventor's employers, then it can still have value if it's protected by a patent. And this is a business model that some people follow. So that's our first case study. I'll pass on to Katie now.
So in this second case study, I'm going to talk about a startup company called QTIP. And QTIP was a spin-out company from Cardiff University. It was established in 2003 by Professor David Barrow. And initially, QTIP was based around Professor Barrow's research interest, so microfluidics and lab-on-a-chips. And over time, those business interests evolved, and their main focus became drug delivery technology. So it's quite common when you have a startup company that in their early years particularly, they do evolve their business interests. So once QTIP had come into this drug delivery technology, they developed a new process for encapsulating drugs into polymeric microspheres. So those microspheres can be used as an injectable therapeutic, and they offer controlled and sustained drug delivery. So the research program that QTIP undertook eventually led them to develop a process that they called QSphere. So that's a process for making these drug microspheres, and had the advantage of increasing the uniformity and encapsulation efficiency. And they did this with a process at a lower cost, improved scalability, and less waste than what was used before. So how did IP help QTIP on their journey? Well, QTIP patented their technology, their early technology, in the early 2000s. So when I mentioned QSphere process, then I said there were quite a few advantages, and that should be a flag that, hang on, we might have something that's patentable here. We're having advantages over what's already existing. So having their technology patented was attractive to investors because, as I said before, it's showing that they're innovative, and also it's protecting their intellectual property and preventing those competitors working in the same area. So QTIP ended up attracting millions of pounds worth of investment to further develop their system. They were then able to conduct in vivo research studies and collaborate with pharmaceutical and biotech partners. So that in turn led to them patenting more technologies. So they've then got additional revenue streams and business opportunities. You might also notice when I mentioned this main process, QSphere, they registered that as a trademark. So Tom, early on, he mentioned that trademarks protect brands and they prevent others from using or registering the same or confusingly similar brand names. So having the QSphere process as that as a registered trademark, QTIP were able to build on their brand identity. So then the big step for QTIP happened in 2014, where they were acquired by Midotech Pharma. So Midotech Pharma is a nanomedicine company that develops and commercializes therapeutic products to enhance the delivery of medicine. So Midotech's business interests were complementary to QTIP, so they could see the value in acquiring that business and their technology as part of that business. QTIP had a strong patent portfolio and they'd protected their brand, so this will enhance their value. They had well-drafted patents, so that clearly defined what technology was protected, which makes it easier for the acquiring company to identify what's protected and assess that value, and also assess the risks that they might be exposed to. Having this trademark as well also allowed the acquiring company to further build on the brand identity. So overall, I think the advantages for the acquiring company of having this strong intellectual property portfolio was that they were reducing their risk, and they could assess what ways competitors could work around patents, for example. And then the advantage for QTIP is that they were able to develop this invention and put it into practice, but then they were able to exit from the business and they could shift that commercialization to the acquiring company. So now going to hand over to Tom for our third and final case study.
Great, thank you, Katie. So we've done the two approaches so far, which is development of technology and then license it out. We've also had a startup getting to a certain size and then selling as a business. And now the third case study here is one where a company has decided to commercialize its technology itself. So going from startup to sort of fully fledged commercial operator. And here for this case study, we're using recycling technologies. So recycling technologies are a recycling equipment manufacturer based in Swindon. And what they've come up with is a system for recycling hard to recycle plastic waste. So that might be composite films or sort of currently unrecycled hard plastics. Any plastics really can be shredded up. And their system or their approach to this is to make a modular machinery of a relatively small or sort of medium-sized capacity. That machinery can be mass manufactured and then so made at a relatively low cost, then supplied to sort of waste handling centres that are close to the source of the waste plastic. So rather than having to collect plastics and transport them over long distances to a very large centralized facility, you can have these much smaller units located where the waste is, and then transport the sort of higher value oil around. So their system is a chemical recycling system, so it subjects the plastic waste to pyrolysis to produce, to break down the polymers into an oil or an oil and wax mixture. And then that product, which they've called plaques, can be sold on to oil processors for use in existing sort of alongside regular oil, or instead of, to make more plastics or products, whatever really. It began life, recycling technologies, as a spin out from Warwick University, from academics working at that university back in 2011, designing systems for pyrolysis of mixed plastic waste. And they're led by currently, and were then led by their CEO, Adrian Griffiths, who sort of led the commercial side of things, and over the years developed their own technology until they got to the stage of being able to begin operation of a test plant in Swindon in 2018. So you can see this is quite a long time scale. This is the reality of a spin out, I think, commercializing itself, particularly in this kind of sector where you're making advanced machinery. It takes a while to get there. So how does IP fit into this journey? Their first patent applications, we filed them back in 2013, sort of focused on their sort of technology goals as they were then. And over the sort of following years, patents were granted in the UK first. That was quite quickly. In the US a bit later, and most recently in Europe. It does take a while to get patents granted, particularly in the major jurisdictions like the US and Europe. There's a certain amount of negotiation with the patent office, and it just takes time. These all came along at quite helpful points in recycling technologies development, and as these patents granted, they help to sort of reassure investors that the technology is unique. So you only get a patent if you're novel and inventive, but also that the company is taking steps to protect its intellectual property. So I understand that has been pretty useful as the business has grown. More recently, the patents that they already have and applications that are pending, they give some extra leverage and collaboration agreements with larger partners. So if they want to go into some kind of joint development agreement, as they are, this is sort of fairly recent development, is working in the field of polystyrene recycling and teaming up with major polystyrene manufacturers that are much bigger than they are. The patents that RT recycling technologies have to start with shows what they're bringing along to this and makes it clear what they had before they got into these agreements. Alongside the patents, there are some trademarks as well. There's the name and the logo, and also I mentioned earlier they're calling their product plaques. Some of the value in that is being able to clearly brand their product, their schematics and what they're doing, and it helps communicate what the goals are of the business. Their makings sounds a bit like wax, and that allows you to really get across the message and make sure that they've got space to use their terminology, their names on everything. So intellectual property has been pretty helpful, but I think what you can see there is this is quite a long-term thing. So thinking about timing, thinking about when you do things, how this fits into the overall approach is important. And considering that point about timing, it does take a while for these things to come to fruition. I said earlier that your strategy, and in particular where you might file patent applications, is quite relevant. So thinking about the business plan, if the strategy is to develop technology and license it out, then having patent protection in all of the territories of your potential licensees is going to be really valuable. So thinking back to our first example where Unilever were wanting to license that technology rather than commercialize it, getting protection in the major developed economies, Europe, America, Japan, etc., gives them good licensing opportunities. If, on the other hand, your intention as a business is to commercialize yourself, then thinking about there only being a limited amount of budget for everything, then perhaps the best value might come from getting protection in the countries that you plan to operate. And that might be more modest. If you're a startup, that might just be Europe, or it might be Europe and the US. So you can see how these things tie in together. And of course, business plans do change over time and things can be adjusted. So we're going to wrap up now with our summary. The points we've made here are that intellectual property can and should be an integral part of the business strategy. So where's the business going? What does it want to get from this? What kind of intellectual property is being generated as well? Is it technical inventions? Are there some other aspects as well to do with design and branding? And then how does intellectual property fit into that business plan? How do we make use of it? Are all things to consider from the outset. As we said earlier, ownership matters. Ownership is really important. So who are the inventors? Who's contributing? Have we named them all? Are there any that aren't really inventors that might complicate the picture on ownership? And seek professional advice. Kate and I are friendly people. I'm happy to talk to you. We generally, as a matter of course, will speak to people for an initial consultation without charging anything, and then we can see where we go from there. But much better to get that all lined up in advance than get into a pickle later on. So that's what we were going to cover today, and we've left a little bit of time for questions if there are any, and it's, well, up to you really whether you want to pass anything through.
Thank you very much, Tom. Yeah. If you can take the slide down so we can start face two people and then answer their question. Thank you. Yeah. So any question for Tom and Katie? Okay, Tom, I have a quick question about that. So you mentioned about the patent with the university. So can you give us like a rough time scale? How, for example, when we engage with you, yeah. So what's the rough time scale from for example, we have a good catalyst, but we want to publish, have some publication as well. But before publication, you mentioned we need to patent it first. So what's the general time scale we need to leave for this, before we release to any publication?
So the important thing is to get an application filed. Once you've got an application filed, you've got your sort of all-important first date, and then you, broadly speaking, are free to go ahead and disclose. So you don't need to wait until you've gone through the whole of the process to get something granted. You just need to get that application on file. That's the date that matters. So thinking about timescale then, it does take a little bit of time to write a patent application. They can be quite complex legal documents, and it's worth thinking really carefully about what goes in there, what doesn't go in there, and what you're wanting to claim is your invention. So we generally want a few weeks to write something like that to make sure that we've had time to think about it and properly digest it. So we are talking weeks essentially as the minimum timescale. I mean, things can be done very quickly if there's a massive urgency, but that's better. The slight difference to that, or slight complication then, if you like, is patent applications aren't published until 18 months after they're first filed. And also you have a first 1 year period where once something is filed, you can follow it up, sometimes with extra details to get protection in other countries. And generally, as a matter of principle, it's better to keep things confidential during at least that first year, or ideally up until publication, but that's not always possible. So that's more of a nice to have than an essential. The main thing is that something is filed before it's disclosed.
Excellent, thank you very much. So now we got a question from our audience, Paris. Kitty is for Kitty. Katie mentioned something about the idea being new, to make sure the idea is not in a research paper first. To know when to fill the application, can she please elaborate on that? Can we not mention our idea in a paper before filling an application? I think this is a follow-up question to Tom.
Yeah. So I'll just go back and reiterate my point was, if you disclose your invention before filing a patent application, that's your patent application is assessed against that disclosure. So if you've given all details of the invention in a publicly available document, then you can't then have a granted patent because it's disclosed to the public. I would say there are some jurisdictions where there's some grace periods. So in the US, there is some way around that. But as a general rule, don't disclose before you file a patent application. You do, so with the idea of mentioning an idea, it's kind of a grey area, really. So it depends how much detail you're putting in there. If you're just being very vague, there potentially isn't enough detail in there that it would be deemed to be a novelty destroying disclosure. If you're putting in lots of detail that someone could put into practice, the invention, then that's going to be bad for a patent application. So I think general rule of thumb, think before you disclose, and it's always best to seek advice before you do disclose, just to avoid any problems later on. So Tom, if you've got anything to add for
that? No, I think that's a good summary.
Good.
Excellent, yes. Yes, any other question? Yeah, I got another follow-up question. Yeah, so as you mentioned, because also our audience asked, so about the idea and the patent and the fail and all the future patent. So because sometimes it's not very not every time possible that your idea actually will be patent until you publish it. So because after you publish it, then sometime so the industrial partner or something will approach to you, and then so do you think do you have any case like this before that people publish something, but after all, okay, they realize it's like something we might be able to extend the idea or explore something industrial applications and we fail it. So in that case, so do you have any kind of experience on this to give some advice to the researchers?
So that is a kind of tricky situation that can happen. You don't realize it's going to be useful until after putting it out there. The basic answer is just that that concept is, once it's out there in the public domain, it's there. And the principle here is that once something is publicly available, anyone's free to use it. So the system doesn't allow you to try and get patent protection for something that was already out there, and that's protection of the public. So people don't get caught out going, well, I can use this now, I'll try using it, and then suddenly someone has a patent later on. Having said that, if it turns out that your sort of general scientific concept looks like it might have application industrially or commercially, the fact that it could be taken and used industrially, that might be an invention in itself. And so you do see this. So you see technology that was thought of in one field then being used in another, and that could be patentable. We're in this gray area of inventiveness then. It's how obvious would it be to take it there? But this is not very chemical, but a sort of a broad example then, if you like. The Dyson vacuum cleaner, the cyclone technology, the original sort of bagless idea, that approach of using a cyclone to separate entrained particles from an airstream was used in industrial filters, like in sort of coal mines and things like that. Downscaling it for use in a vacuum cleaner was not known, and that gave Dyson that sort of ability to protect that with patenting. So you can kind of see how something that's developed in one area, if it wasn't obvious to apply it somewhere else, you may still be able to get some protection.
Thank you, Tom. We got another question from our audience, Norman. How much money required for patent idea?
How much money is that?
Yeah, I think probably he asking how much resources we need to put into the money from you mentioned during the conversation, the presentation is you can apply some by third party, but I think maybe the audience just inquire what's the general level kind of funding they need to prepare for if they want to fund by themselves.
So when it comes to filing a first patent application, a big part of the cost is me and Katie. It's the professional work in preparing the document. Realistically speaking, just to get that first application on file in this kind of technology, aerocatalysis, it could easily be £6,000–8,000, that kind of amount. That's drafting and filing in the UK. If that is then followed up with an international application, then that might be a similar amount again a year later. And then if you want to take that on to individual countries around the world, that can be sort of similar amounts per country. It varies quite a lot. To get a bit of a feel of costs, I think it might have been posted in the chat somewhere already, certainly on the end of our slides. We have a guide to patents on our website, and that has some indications of costs and how that flows through.
Thank you very much. Yeah. Any more questions from our audience?
Well, I've seen a question in the bit from my old supervisor, Paul. So I can answer that. Paul, nice to see you. Well, not to see you. You can see me. Nice to hear of you again. You said you sometimes see world patent. What does that mean? Generally, that means a world patent application. There is no world patent. These are sort of national and regional rights. So you can have a Europe-wide patent, but generally these are sort of country specific. But you can file an international patent application, and that is something that's a bit like getting your foot in the door. It's sort of buying the option to then get patent protection in other countries. So the way we would typically work is you might file your first application in the UK, just the UK, follow that a year later with an international application, and that gives you the opportunity to go pretty much everywhere around the world. And then 18 months later, you have to decide where you really want to go. And then it's a country by country point where you have to make that decision. And if you don't go somewhere then you've missed out, that's it. But these are all separate rights. These are all examined by the local patent offices and can get to slightly different outcomes.
Yeah, thank you, Tom. Yeah. Do you have any more questions for Tom and Katie? Yeah, I have a quick question about the engagement from the, especially I think today the most audience are from the university and the institution. So to engage with your company, you mentioned something during the presentation, how to contact you. But could you brief them that what's especially for the student, yeah, sometimes if they are thinking their idea may be useful, so or early career researcher. So is there any way that you can suggest them, because you mentioned that the early engagement is important. So do you think what's the critical time that they should be able to think to engage with you? What's the melting point that they should start to contact you when from your experience with the previous collaborators?
Katie, do you want to answer that, or shall I carry on speaking?
Yeah. So really, with engagement through to us, it depends on the university or the institute. Quite a lot of universities and institutes have their own technology transfer teams, so they're a really useful first port of call, and they can talk to you about the initial steps, and then if they think the invention it's worth pursuing a patent, then they can engage us. In terms of when, I think it's never really too early to start talking about a patent application. Once you've got an idea and you think there might be some commercial value there, then you should be talking to tech transfer or patent attorneys. It's the question of when you actually file a patent application that you need to think about a bit more in terms of how much data do you have. So that goes back to when I said you have to sufficiently disclose the invention. So that will be in terms of data and examples to back up what you're claiming. But I think the initial step you can do fairly early on. Yeah, Tom, anything to add?
No, I think that's exactly it. I mean, so we patent attorneys have to have a science or engineering degree before we go into the profession. So understanding the invention is something we can do, we should be able to do. And as Katie said, we can help sort of suggest further data that might be useful if you sort of speak to us early enough.
Yeah, thank you very much, Tom and Katie. Yes, so for all the audience, if you have any idea, you think it might be potentially be patent, so now today is a good time, you can approach to them and then start the conversation. It's never too early. So yes, so I think today is pretty much there. So the webinar is recorded. So if you want to refresh yourself with the idea Tom and Katie shared with us, you can go to our website. There will be a recorded webinar you can watch up, and also you are all welcome your colleague and collaborator to contact Katie and Tom in the near future. Yeah, thank you all very much.
Thank you.
Bye.
Thanks.
Bye.
Bye.